on the 6th of April 2025. So quite soon, but still some time to get prepared. So I thought it would be a good time to see what we should be doing in advance of these new types of leave coming in. A minimum wage update, which is also coming into force on the 6th of April. And as well, we're just going to finish on just a small section on some government proposals at the minute to extend parental bereavement leave to cover miscarriage before 24 weeks. So starting off with the new Neonatal Care Leave and Pay Act 2023. So you've probably heard about this one before because it was actually enacted in 2023, but that was just the framework or the enabling legislation that got through Parliament. It didn't actually have the kind of bulk of the detail of how it would look and how it would work practically. But we recently got that detail in a set of regulations that were passed in the 17th of January 2025, so not long ago at all, that gives a bit more information about how this leave's going to look in practice and when it's going to come into force. So the date we've been given in those new regulations is the 6th of April. So that means by the 6th of April, we should be ready with our policies to honour this type of statutory leave should an employee require it. So it's thought that this will help 60,000 parents per year presently. So at the moment, so before this has come into play, if someone did have a child prematurely, their family leave would start. So if it was maternity leave, that would start. And the kind of practical effect of that is that they might be returning to work when their child's either still in hospital or only very recently home. So the idea of this is to kind of bridge that and make sure that they're getting the time in hospital to care for their child, but then also the time at home to settle in. So we'll go through the kind of requirements and the moving parts of it practically. Starting off with the eligibility criteria. And as we go through, you'll hopefully see that some of it is the same to other types of statutory family leave, like maternity leave. But there are a few key differences that we'll go through. So in terms of eligibility, it's going to be a day one right. So employees will have the right to take this leave from the instance that they start employment. And we're still waiting for it to be further defined, but we'll know that the employee must have a parental or other personal relationship with the child, and that child has in the past or is currently receiving neonatal care. In terms of a definition of neonatal care in the legislation, we don't have that pinned down yet, but we do know it's going to mean care of a medial or palliative nature. And it must start 28 days of the day after the birth. It must continue for a period of 7 days or more, and that's starting after the day that the neonatal care begins. So in terms of additional issues, it's thought that the regulations might also cover where a child receives neonatal care on more than one occasion. And as well as that, they actually currently do give us the information for the scenario that there's a multiple birth. So if, for example, someone has twins and there's more than one child and they both need neonatal care. So the regulations tell us in that scenario that the maximum amount of leave that can be taken is still 12 weeks. So there's no right to any sort of double or extended leave if it's a multiple birth. So the neonatal care leave taken must last at least a week, must be in blocks of weeks. So we're not dealing with days or anything like that. It's blocks of weeks. And the maximum of leave that can be taken is 12 weeks. And this is an additional to any other statutory family leave entitlement they have. So whether that be maternity, paternity, they'll still have, say, their full 52 weeks entitlement to maternity leave and an additional 12 weeks neonatal care leave. Where it gets a bit different with neonatal leave versus other types of statutory family leave is when that leave can be taken. So employees can opt to take it at the time the child's receiving the neonatal care, so straight away, and that would be called Tier 1 leave. But they can also choose to take the neonatal leave later, so at the end of their, say, maternity leave, and that would be Tier 2. So leave taken anywhere out with the first instance the child is receiving neonatal care would be called Tier 2 leave. We'll look at that in a bit more detail because that's the main difference that sets this apart from other types of statutory family leave. So the notice that we were just discussing, so what's required on that? The employee must give notice of their intention to take this leave, and I've listed there, and you'll have a copy of these slides, the different things that the employee must give notice of, give details on within that notice. So there's a lot of eligibility criteria and moving parts with this type of statutory leave. So this should answer a lot of the questions that you need to know to be able to process the leave. So it's things like the child's date of birth, the date they started receiving the neonatal care, the date the care ended, if applicable. So if they're applying for that leave or pay retrospectively when it ended, the date on which the employee chooses the period of statutory neonatal leave to begin, the number of weeks notice is being given for, and confirmation that they meet those eligibility requirements that we discussed at the start. So sometimes an employee will be given notice to take the leave, but the care will be ongoing. They don't have an end date in sight. So if that's the case, that's fine. They would just need to give the date it starts, but they must notify the employer of the date that it ends as soon as it's reasonably practicable, because at that point the right to the leave and pay will end as well. And if the child stops needing neonatal care, but then later on needs it again, the employee must notify the employer as soon as reasonably practical. So going back to what I'd mentioned briefly before with the Tier 1 and Tier leave, the notice, what's unique to this leave is that how you give notice will change depending on if your employee is requesting Tier 1 leave. So that's neonatal leave while the baby, immediate leave while the baby is receiving the care, or Tier 2 leave, which would be leave at the end of any period of maternity or adoption leave. So if it's the immediate leave, the notice requirements here are a bit more relaxed, and I think the intention behind that is that, you know, it's not really reasonable to be able to foresee needing to take this type of immediate neonatal care leave. So what they say is that the notice must be given in respect of each week of leave before the employee is due to start on the first day of absence in that week, or as soon as reasonably practicable. So really a week's notice. But if that's not feasible, then it's just as soon as reasonably practicable. And because of the kind of immediate urgency of this Tier 1 leave, there's actually no need for it to be in writing. I imagine oftentimes it will be in writing, but the legislation or the regulations don't specify that Tier 1 notification needs to be in writing. And doing a bit of reading on this Tier 1, it's thought that in practice, this is most likely to be used by the child's father or mother's partner, as the mother's most likely to be on maternity leave in that Tier 1 period. So it's thought that the Tier 1 and immediate leave with a more relaxed notice notification rules is thought to be used by fathers and mothers' partners. So for leave taken later, Tier 2 leave, because that will be taken, you know, most likely at the period of at the end of any maternity leave, there is more notice requirements because it's more of a planned period of leave. So that must be given in writing. And depending on the length of the intended leave will depend on the time, how much notice they need to give. So for a single week, notice must be given no later than 15 days before the first day of the intended leave. And if the leave, sorry, is 2 or more consecutive weeks, it's 28 days notice before the first day of the intended leave. So 15 days and 28 days, depending on how long the leave is. And the regulations do say there that both the employer and employee can mutually agree with each other to waive the notice requirements. So that could also include shortening them or being just generally more relaxed about the notice requirements. So that's the main difference, that the leaves kind of tier 1 and tier 2, and that's just to reflect the fact that it can be taken immediately or it can be taken at the end of a period of other family leave, so just a bit different there. And hopefully the rest of what we're going to discuss is more a refresher, because most of this will apply to other types of statutory family leave, like maternity leave, paternity leave, things like that. But in terms of return to work after neonatal leave, it's just following a similar format to other types of family leave. So all contractual terms will be maintained throughout the period of leave, with the exception of remuneration, because they will be due either statutory or company neonatal pay. And they'll have the right to return to work after the leave on the same job, or depending on the length of leave overall, if they're adding it to, say, for example, maternity leave, it has to be a job that's on no less favourable terms. And we don't know this information yet. We're still waiting on future regulations being provided, which give us that granular thought that they'll deal with making someone who's on neonatal care leave redundant, or after their neonatal care leave redundant. So we'll keep members updated on any more developments in the regulations. In terms of pay, it's the same qualifying requirements as for the leave. So, you must have the relationship to a child, the child must be receiving neonatal care. But in addition, it has the same kind of requirements that you'll see in other types of statutory family pay. So for the pay, they need to have at least 26 weeks of service. So while you only need a 1 day service, it's a day one right for the leave. For the pay, you do have to have been with your employer for 26 weeks. And at the end of the relevant week, they must be entitled in that, earnings in the 8 weeks ending in the relevant week must not be less than the lower earnings limit, which is currently £123 per week. So that applies again to other types of statutory family leave, and that will rise in April to something a bit higher. So in terms of who pays, normally the employer will be liable to pay the neonatal care pay, but the regulations in the future might bring in some sort of liability for an employer that ends employment to deliberately avoid paying the statutory neonatal care pay. So that's further detail that we may get later. The rate of pay is liable to be the same as for other types of family leave. So currently that would be £184.03 a week. But in April 2025, we already know that that rate is going to increase to £187.13 per week. And it will be paid in periods of weeks, not days. However, the regulations to come will likely provide for payment in non-consecutive weeks and how that will work. But again, that's a kind of grey area right now that we don't have the detail on. So some employers might already have something in place which mirrors this, a more enhanced statutory scheme that perhaps offers some sort of enhanced pay. And what the regulations give provision for is for the employee to choose the scheme that's more favourable to them. So although this statutory scheme's being introduced, where they'll have the right to statutory pay, if you already have something in that offers, say, full pay, that you just offer right now, as goodwill as a company, the employee will have the right to choose the more favourable scheme. So in terms of what to do now, it comes in the 6th of April, but I would start to have a think about implementing a neonatal leave policy that just makes clear, I think particularly the notification requirements, and just, the key information on the new type of leave. Or if you just have a family leave policy that sets out the different types of statutory family leave, just updating that to have its own section on neonatal care leave. Anyone who's operating the policy, so whether that be HR or anyone who's working in your office, I would just have them trained on the new leave, or at least just have a working knowledge of where to go and find the information should an employee request the type of leave or require it. And just keeping up to date on any further regulations. You've maybe picked up throughout that we've got some of the information, and I'd say the key parts, but there's just some small nuances that we're still waiting for further regulation on. So we'll certainly put out members' briefings with any information that we think members need to know if there's any more developments. But some time to get it all sorted ahead of the 6th of April. Just a quick highlight on the national minimum wage. So as well as the new neonatal care leave coming into effect on the 6th of April, that's also the date when the new national minimum wage rates come into effect. So you'll see for the national living wage, so for the 21 and over, there's a 6.7% increase to £12.21. For 18 to 20-year-olds, it's going to be £10 an hour. So that's actually a 16.3% increase. Also, what I've been hearing is the quite big jump for 16 to 17-year-olds and apprentices. So that's an 18% increase up to £7.55. So the Low Pay Commission have reported signs this year of employers finding it harder to... Sorry, can whoever's having some background noise just put themselves on mute? Thank you. That should be it. So the Low Pay Commission have reported signs this year that employers are saying they're finding it hard to adapt to these increases, just with the kind of the way the rises are working. But they have anticipated that the consultation's still going to go ahead over the next year on the government's goal to reduce the national living wage rate from 21 to 18. So if I just go back to the slide before, that would essentially be eradicating this 18 to 20-year-old category, so that there's one national living wage, 18 and over, and just for argument's sake, for next year that would all be on 12.21. So it's looking like that consultation's still going to go ahead, despite these reports from employers. So in terms of things that we've been seeing cropping up, it's a good time ahead of the 6th of April just to have a bit of a sense check on your current salaries to make sure that no one's going to creep below the new national living wage rate of 12.21. Things that I've seen cropping up are salary sacrifice schemes. So if you have an employee who's in a salary sacrifice scheme, and they're around that national living wage rate area, I would just have a look to make sure they're not sacrificing so much salary that they sit underneath the national minimum wage rate. So although they're sacrificing that salary because they're not contractually entitled to that money anymore, they're sacrificing it into a pension. It does reduce salary for national minimum wage purposes. So that's one that's worth having a look out for. The other one is employee savings schemes. So that's the type of scheme whereby an employee will sacrifice or reserve a bit of their hourly rate, and rather than see it in their pay each month, and maybe in the summertime and at Christmas time, they'll receive a big payout of all that saved salary. So what that means, in Iceland actually got into a bit of hot water for one of these schemes, is that for all of the weeks that they make the sacrifice or they take the saving out their hourly rate, if they fall under national minimum wage rate, for all those weeks, they're being paid uncompliantly with national minimum wage. And it's only at the weeks they get the big payouts that they're being paid compliantly. And that's because it's calculated on review periods that mirror the pay periods. So if you have someone who's paid weekly, every week they need to be paid above the national minimum wage rate, or if it's monthly, every month they need to be getting paid above. So if they are, taking any sort of savings out of their main salary, in a pay period that brings them under, that pay period would be paid under national minimum wage. So it's worth having just a review to see if you have any type of savings schemes, anything like that, that might be taking people under national minimum wage. And then the last one is just making sure that, particularly, at the end of employment, that any sort of deduction from wages isn't taking someone below national minimum wage. So there are a whole number of deductions that don't reduce national minimum wage for calculation purposes. So things like if you're deducting overpayments or tax and national insurance, that's fine. But there are some sorts of deductions which can reduce national minimum wage. One that probably comes up the most might be deducting for training costs. That can be fine in some instances, but if, for example, the training wasn't voluntary, so if they're being deducted a charge for a training that they had to do or were contractually required to carry out the role, and there was no prior agreement in place, then if you deduct that amount off their salary and it takes them below the national minimum wage, there could still be a breach of the national minimum wage regulations. So if you're making any sort of large deduction off any one salary, it's worth having a look just to make sure that that's not going to be the type of pay that can reduce national minimum wage. So I'm planning actually to put out a longer blog post or members brief about these three issues separately. So once that's ready and published, our business support team will likely put that in one of our newsletters or on our website or LinkedIn. So it's one to keep an eye out for. But just wanted to highlight while I have you all here. And lastly, just a quick note on some current government proposals which will extend statutory parental bereavement leave. So we don't have any sort of legislation in place for this yet, but just wanted to highlight it because it's been brought up in Parliament. So since April 2020, employees have been eligible for statutory parental bereavement leave if they lose a child under the age of 18 or experience a stillbirth after 24 weeks of pregnancy. So if they meet that eligibility criteria, they would be entitled to 2 weeks of leave, which could be, one block of 2 weeks or 2 separate weeks. And there's statutory pay linked to that as well, at the rate discussed earlier, the £184.03 per week, or 90% of average weekly earnings, whichever of those is the lowest. So that's how it exists at present. But what's been brought up in Parliament is a proposal to amend the current Employment Rights Bill, which is going through the legislative stages at present, and it would extend the right to those who experience a miscarriage. And this is thought to align pregnancy loss before 24 weeks with the provisions in place for pregnancy loss after 24 weeks. So rather than just kicking in at 24 weeks, it would, acknowledge and appreciate the pregnancy loss that takes place 24 weeks before as well. So that will cover things like miscarriage, ectopic pregnancy, molar pregnancy, a whole list of issues here. So again, this is at very early days. It's not gone through yet, and the Employment Rights Bill certainly hasn't been amended yet, but we'll keep you posted on this one as it goes through, if the proposal is accepted, and let you know any sort of changes and things you need to make to that as well. But other than that, that will be us for today. If anyone has any questions, I'll stay on and hang back. So I appreciate there's a lot of information for first thing in the morning. So if anyone has any questions, just let me know. So if there's no questions, that will be us, but I'll hang back anyway, just in case. Thank you very much.
Thanks, Amie.
No worries, thank you.
Thanks.
Thanks, bye.
Bye.
Thanks, Amie. Have a good one. Bye.
Thank you.